Good morning, everyone, and welcome to our webinar today on the Assisted Decision-Making Capacity Act and Communication. My name is Eleanor Flynn. I'm the Director of the Centre for Disability Law and Policy here at the University of Galway, and I have the pleasure of introducing today's panellists and monitoring the Q&A for today's webinar. We're here at the Centre for Disability Law and Policy. We're all very excited about this event, and we have had the immense privilege of learning from Dr. Taighde Éireann as she has conducted this really important research onto the experiences of young people who are non-speaking, sometimes speaking, or communicate differently, and their experiences of preparing for their interactions with the Assisted Decision-Making Capacity Act. As you'll hear from Taighde in a short while, she's also done some really interesting research with a wide range of professionals who have responsibilities for implementing the Act or engaging with the Act in their professional practice, and learned some really interesting things about their knowledge of the Act, their familiarity with the concepts, and the challenges that they've experienced in applying the Act in practice. We're also very pleased to have with us today some of the organisations that were part of the advisory group for this research, especially NeuroPride and the Decision Support Service, and we'll hear some reflections from them later on in today's agenda as well. And I'm delighted to see such a wide range of attendees have signed up for today, and people from all sorts of backgrounds with lots of different knowledge and experience to bring to the table. So I'm sure you'll all get quite a lot out of what we're going to hear about today, and there'll be lots of things you can take away and use in your practice from today on. So without further ado, I'm going to hand you over to my colleague, Dr. Taighde Éireann, to share the findings of her research with you. Over to you, Taighde.
Thank you, Eleanor. I'm delighted to have the opportunity to share the findings and an overview of my research with you all this morning. So, as Eleanor has outlined, the research focused on my slides should be up now, a technical glitch, but young people who are non-speaking, sometimes speaking, or communicate differently, and how the Assisted Decision-Making Capacity Act applied to them, and how they could utilise the different support options and changes under the Act. As many attending today's webinar will be aware, the Act commenced on the 26th of April 2023, and so when I was doing this research from September 2023 until now, we were very much in the early stages of implementing the Act and understanding how it was actually going to operate in practice. And the Act made considerable changes to the law in relation to legal and mental capacity in Ireland, including abolishing the ward of court system and introducing new formal decision-making arrangements, such as a decision-making assistance agreement, where somebody can choose to have who will help them or support them in making decisions, a co-decision-making agreement, where somebody can decide that they'd want somebody to make decisions with them jointly, and also a facility whereby when a court declares somebody to lack capacity, they could have a decision-making representative appointed to them to make decisions on their behalf on specific or across a number of different areas. The Act also made changes to the function, or placed the functional assessment of capacity, I suppose, on a statutory footing in Ireland, because we always had a functional assessment of capacity in Ireland, but this placed it on a statutory footing and outlined the different steps that were required in order for somebody to have capacity or to be seen to have capacity. So they needed to understand the information, they need to retain the information long enough to make the decision, they need to use and weigh the information that's relevant to the decision. And the part that I was particularly interested in from the purposes of this research, they need to be able to communicate their decision to other people, whether by talking, writing, using sign language, assistive technology, or by any other means. And I was interested in exploring how that concept of any other means was going to be applied and understood, because the legal nerd in me very much thought that that's quite broad. That could cover an awful lot, but at the same time, will it in practice, and how will that work, or how will people think about capacity in that sense for people who communicate differently? But also to make sure that a group that is often excluded in this kind of research, a group that is often overlooked or may be viewed if you have high support needs, that you may only be able to access the highest tiers of some of these things, or that you may lack capacity and therefore have to go to court. Is that how it was going to operate in practice? When in fact supported decision making very much came from across the world, groups that had high support needs and communicated differently or were non-speaking, and was used and kind of came from their parents and supporters. So these were all of the things that I went into the research interested to explore. And in doing so, I set out to do it in using a human rights-based methodology. So this covered working and looking at how the Act was operating in line with the UN Convention on the Rights of Persons with Disabilities. And while the Act isn't fully compliant with the Convention, it's been enacted to bring us in closer compliance with it. And I was interested in seeing how it could be applied, or if it was applied in a way that maximised and promoted people's human rights. I also wanted to do it in a way that centred people's voices and their lived experiences, and I did this in a number of different ways, through working with an advisory group, and as Eleanor has mentioned, some of the representatives of the organisational representatives of that advisory group are speaking here today, but on that group there were also people who were non-speaking, sometimes speaking or communicated differently. There were their parents and supporters. I had representatives from the National Advocacy Service, AAC researchers, speech and language therapists, a number of different perspectives that provided really invaluable guidance on how this research should be structured and done. And it wouldn't be as rich or as detailed without them. And I have to take a moment and thank them all for their contributions to the project. In conducting the research then and trying to gather information, I took two different approaches. So I wanted to work directly with young people who were non-speaking, sometimes speaking or communicated differently, and I wanted to find out their experiences and talk to them and their supporters directly to figure out what it was like if you were creating or registering a formal agreement, how had the Act influenced or interacted, how they had interacted with it, how it was come into their lives in different ways, and what were their experiences on the ground and how that had worked. I decided to call this a case study approach, where people were, they would be interviewed, they could submit documents, they could submit recordings to me, they could draw pictures, they could do whatever suited them best, to be honest. It was very much open to their methods of communication, their access needs and their comfort levels. And this could be on one occasion or across multiple different occasions as the need arose across the research. As it happened, it was mainly an interview or a chat style interaction with people, and we sat in kitchens and in places and had discussions around how they had experienced things, what their likes and dislikes were, and these kind of things. And then there was perhaps a more structured interview sometimes with their supporters following that, or something of that nature. And each of them only had, they were at a very early stage of the process, so they only took part in one interview or in one part of this. I also conducted an online survey of professionals using Microsoft Forms to gather an understanding of a broad range of perspectives to see how they were implementing the Act, what they knew about the Act, and particularly how they thought it applied to people who were non-speaking, sometimes speaking or communicated differently in their practice. I now want to take the opportunity to introduce you to some of those people that allowed me into their kitchens and spoke to me over the course of this research. So the first person that I want to introduce you to is Thomas, and I met with Thomas and his mum Emily in this research. Thomas was 19 years old when I met with him, and he used an app to communicate, an app that was on his phone and on his mom's phone at various times. He sometimes used the app, I suppose is the better way of saying this. He also wrote things down and sometimes decided to use a shorthand that those knew him best were able to do it, where he was like, I'm not taking out my phone, you know what I want, and used body language and gestures and a whole host of other things to communicate alongside it. In talking to his mom, she explained to me, and some of the story I'll go into in more detail later, that they were applying for a decision-making representative order in order to be able to continue to make decisions in Thomas's life, and to avoid some of the experiences that they had with capacity assessments, which I'll share in a bit more detail. Next was Holly. Holly was 17 when I met with her, and despite the Act only applying to people who were aged 18 and over, I felt it was important in this research to understand how people were being prepared for the Act, if they were preparing for the Act, and how this would work for people at that earlier stage, because it doesn't automatically happen just at 18. Sometimes this is a big preparation phase. And for Holly, there wasn't any transition plan in place. There hadn't been any conversations with professionals about the Act as such, or preparing for it in any sort of a structured way. It had come up when they had interacted with the bank around setting up an account for disability allowance, but not really in any sort of structured, help you understand it and how can we go about this sense. When I met Holly, she was using a Tobii eye gaze computer to communicate, but the day that I met her, she preferred to turn her head and use gestures and vocalizations and other things, and kind of body language. And when I say turning her head, it was that her mom, whom I met on this occasion, would hold a finger to either side of her face and go, "Do you want water or do you want juice?" And Holly would turn her head to indicate which option she was choosing. Because they hadn't really had much time to interact with it or figure out information about the Act, I outlined some of the different options that were available to them, and they felt, or Holly's mom Lucy felt, that the decision-making representative order was the most likely option in her case. And finally, last but not least, was Andrew. Andrew was 24 when we met, and he used some words to communicate in response to specific prompts or questions that those who supported him and loved him knew well, but also vocalizations, behaviour, movement, body language, all the ways that we can express ourselves to show that we like or don't like something at any given time. And this was something that I particularly became aware of when Andrew was like, "Bye, Cliona. Finished, bye, this is over, this chat is very much done." And in talking to Andrew's mum, while supported decision making, and he would have a lot of decision making in his day-to-day life and choices and preferences in that sense, his mum felt that a decision making representative order would be the best choice for him in order for her to continue to make the bigger decisions and to have the authority to do that. The professional survey then was online via Microsoft Forms, as I've mentioned before, and had over 259 eligible responses. So there was 268 responses overall, but some of those may have said that they weren't over 18 or didn't consent to take part, and therefore there was only 259 that were ultimately eligible. Of the responses, around 62% were women and 37% indicated they were men. And it was good spread across the country, with 24 out of 26 counties represented. About 60% of the people who responded to the survey were employed in the public sector. So there was a big kind of perspective across different areas and across different backgrounds in the survey, including a range of professional backgrounds. So some of the actual text on this may be quite small, so I'll go through the different backgrounds that people entered. This was an open text box question, so people could describe themselves in a variety of different ways, and maybe if they wore two hats or came from two professional backgrounds, that was sometimes put down. So in the interest of creating a chart and making it clear for everybody, I had to categorise them somewhat. So you'll see here we have advocacy, dentistry, the medical, or people who describe themselves as medical professionals, practitioners rather, doctors of a whole range of different backgrounds. So some people would just say a doctor or a medical practitioner, and others would be very, very precise and say a consultant and give the very exact background that they were in. So this is all categorised then in order to represent it on a chart. There were representatives from the emergency services, including EMTs, paramedics, the fire services, and a range of other backgrounds. From financial services, including banking, credit unions, and the post office, solicitors and barristers in law, occupational therapists, nursing and midwifery, pharmacy, physiotherapy, social work, social care work, and speech and language therapists all took part in the survey. And you'll see there that people who noted that they were doctors or medical practitioners are probably by and large the biggest chunk of people who took part in this survey. But across the board, there was a lot of, I suppose, different health and social care backgrounds represented here. But it was important for me to get perspectives from outside of that because, of course, disability is not just a health and social care issue. And the Act does not just apply to that. It applies to both personal welfare and property and affairs, and across a whole different range of services where people who are sometimes speaking, non-speaking, or communicated differently should have the opportunity to access these services. So that's who took part, and now for a flavour of some of what they said. So there were three main themes that came across when I was analysing the responses to this research, and I combined the responses to the professional survey and those from the case study research when I was doing this. One of the first major things that came out in the research was the content of the law. So people talking about whether it was the changes that had happened or the challenges that they encountered in the qualitative aspects of the survey in particular, and talking about specific parts of the law in doing so. So the abolition of the ward of court system was a major thing that came up here. Some people thinking it was great. And that it would be very important and that people wouldn't be funneled in that way anymore. And then others expressing concern that, okay, in the absence of that, would other mechanisms, such as the inherent jurisdiction of the courts, be used to fill gaps? And was this really what we wanted, or was this appropriate? Another main theme that came across in relation to the law or specific elements of the law itself was many professionals in particular talking about an increased focus on capacity assessments. And this came up, I suppose, across the analysis then when I was looking at it. I was seeing that maybe we were talking about the capacity assessments, but we weren't necessarily have the same corresponding awareness of the guiding principles, and particularly the guiding principle that says that we must take all practicable steps to allow somebody to take part in a decision before we intervene or before we decide that they don't have capacity or start a capacity assessment. So a speech and language therapist who took part in the survey would have talked about an increased work completing capacity assessments as part of the multidisciplinary team. And the occupational therapist would have talked about the four principles, let's say, if you'll see here on the slide, such as not needing to intervene unnecessarily, assuring that there's a least restrictive option, and that we need to assume capacity. But of course there are 8 guiding principles, and some of the ones, like I said, like taking all practicable steps, were being overlooked then in how this was being framed. In other instances then as well, professionals felt like they were immediately reaching for a capacity assessment before they were thinking about how they could support somebody in practice, or at least going for it very, very quickly. So in the other quote you'll see here on the slide, this was in response to how you would support somebody who was non-speaking, sometimes speaking or communicated differently in your professional practice. And in this instances, a gynaecologist said, I would seek a professional assessment of capacity, a third-party appropriate translator if available, and after that I'd have to explore the legal route for a decision-making representative. This was quite a stark example, I suppose, of immediately going for a capacity assessment, but it did appear quite in reference to how you would support somebody on a number of different occasions, and people talking about how they were doing more of these sort of assessments. Often professionals are saying they felt that they shouldn't be doing it, or that they maybe were doing it at times when it wasn't totally appropriate, that there was more focus on this than on other things. So they were recognising this, but it was something that came up quite a bit. It wasn't limited to the professionals either in terms of capacity assessments. An experience of a capacity assessment is what brought Thomas and his parents, really, and his mum, to the idea of needing a decision-making representative order and saying we're not going through that again, essentially, was how they explained it to me. So when Thomas travels in the car with his mum, he uses a seatbelt lock. Or they use a seatbelt lock, because he used to unlock his seatbelt and reach forward into the front of the car, and she felt it was quite dangerous. So this was the solution that they found. And when he moved then to a different service, as he moved on to adult services, they were saying, well, you can't consent to this decision on Thomas's behalf anymore. And we need to understand if he has capacity to agree to this, and how all of this would work. And they arranged a meeting, and there was a number of different forms of back and forth on this, but they ultimately arranged a meeting, and a psychologist, occupational therapist, and speech and language therapist attended the meeting. And they did arrange an awful lot of different options in order to make sure that Thomas could communicate, and that they had different things. So you'll see from the first quote on the slide here, getting back to the lock, the psychologist, occupational therapist, and speech service came in. They had their vision board, they had their pictures of the service provider girls, and they had pictures of the lock. I brought the locks in as well. They had a whiteboard and a marker, and I brought Thomas's phone. So we had lots of methods of communication. So they did try to make that part of the process accessible for him, or try to make sure that he could communicate in a number of different ways. But they did ask him a lot of questions, and he became very, very distressed in the session, and engaged to a certain amount, and then it just caused him too much distress. So anyway, they asked him a million questions, and they drove him insane. They asked him way too many questions. He ended up hitting his head, crying and screaming, and I hadn't seen that in a long time. I did tell them that ye caused that day, but anyway, I wanted to say more, but I didn't. And those were quotes from Thomas's mom, Emily, who was describing the experience of a capacity assessment that day, and essentially told me, coming away from that, well, we're not going through that again. So I decided to explore my options, and quite honestly, there'll be times when I'm just going to be telling him what we're going to do in terms of decisions, and I now need a piece of paper so that we don't have to go through this again. I don't want to be going through this again. And I suppose it was quite stark in how that had experienced, and I can totally understand how she decided that she needed a decision-making representative order, or that she needed to avoid any sort of situation like this ever happening to him again when he was quite that upset. It was also really clear from conversations with her, or when I asked her specifically, she said that she wasn't aware of any sort of preparation to help Thomas be part of the decision before this event, or to increase his involvement in the decision making. And there was different things also that she pointed out to me, which was that he would reach out when he got into the car and ask for the lock. So it was part of their routine. It was part of a thing that he was reaching out for and asking for. But all of this hadn't necessarily been a part of how the capacity assessment was conducted. And ultimately, they decided at the end of this that Thomas didn't have capacity to make this decision. So the other main theme or main issue that came across in the research then was the cultural or systemic change that the act had caused in a positive way, the good things that had come out of an increased focus on the will and preferences of the person, for example, or the way that the act had shifted people's thinking, but also in some instances the need for further cultural or systemic change in order to make sure it was implemented appropriately and it could have the best possible outcomes for people. So to start with the positives, there was, as I said, an increased awareness of the person's decision-making rights, and this came up from a number of different professions and professional backgrounds, and the need to include the person's views, will and preferences. So some people actively talking about, well, it's made me stop and think, or it's given me a new view of disability, or naming specifically will and preferences or the voice of the person as one of the key changes in the Act and something that they needed to focus on more now. A disability activist framed it as follows. They said, other professions are more aware of their responsibilities and are calling on me more and more to assist people record their will and preferences, their consent and decision making, especially people who communicate differently. Increased inquiries regarding financial decision making and difficulties that people who communicate differently are experiencing with financial institutions. There's also increased time spending on researching issues around the Act, seeking clarifications, explaining the Act to other services, i.e. when or when not the Act applies. A paramedic supervisor would have also said that it gave me a new outlook, acknowledge different forms of communication and engage more with the person and think more about the person at the centre of this. And this was one of the big kind of positive cultural shifts that I was able to see. People talking about including the person more, making more accessible information. Now, they were saying that there still needed to be more accessible information, but it was still on the increase. It was still a step in the right direction, I suppose. And that we were kind of thinking about engaging with the person, and that it wasn't necessarily what the family wanted anymore. It wasn't a next of kin thing anymore. It was the person. It was the person at the centre of this, and that this was a key shift in the Act had brought about. However, it wasn't all positive, unfortunately, and the need for the shift to continue and maybe to even broaden out in certain areas was highlighted across a range of different responses to the survey and by participants to the case study dimension of the research. So on the first quote that you'll see here on the slide, a barrister would have said that there is still paternalism among judges and that they're not adhering to the guiding principles. They make very broad orders which are not issue specific. They create barriers to the relevant person, which is a term under the Act, exercising their rights. They talked about inherent jurisdiction for detention and treatment order operating parallel to the Assisted Decision-Making Act, and the process being cumbersome and costly to so many families, so they want to get wide orders just in case to avoid coming back to court the second time. And that was very much kind of echoed or seen by some of the case study participants or the case study supporters particularly, who were saying, well, if we're going to do it now, we need this and we need it just in case. Like I said, Emily, for example, saying, well, we're not going to go through that again. Similarly, Mary would have highlighted, and she was Andrew's mum, she would have talked about how we needed to make sure that this was applied to everybody and that the Act made sure that everybody's voices were thought of. And she was thinking about how really she doesn't feel that this is still true for people who are non-speaking, sometimes speaking, or who communicate differently. So she said, no, I mean, I think for Andrew, with his high support, I think that they were very much still in the situation where it's assumed he doesn't make decisions. It's assumed that he's a passive participant in life. It's assumed that whoever is pushing his wheelchair or whoever is driving his car is the go-to person. And Andrew just gets a little tap on the head and isn't he grand? Really, that's where we are. And it's assumed, I think, by everybody in the society, in the shops, in the surgeries, in everywhere, the banks, everywhere, that he's just a passive person in a wheelchair that is really being minded. And she spoke about challenging this and pushing back on this in a number of different instances, but it's still being very much a central part of how Andrew was being treated and viewed across society. And I think this was reflected across different parts of the research as well, with how people were thinking about how we would approach decision making for people with higher support needs. That the Act maybe has gone so far in changing our mindsets, but this cohort is still unfortunately not included in all that different parts of the cultural shift. This may be somewhat attributed to a limited knowledge, training or awareness that's existing out there. It's hard to know exactly where this thought process is coming from, but this was a finding that also struck me in the research, was that while technically, yes, a majority of the participants in the professional survey at 56% did say yes, that they had attended a training session or an information session on the Act and how it applied to their professional practice, And these ranged broadly from webinars run by the DSS, the HSE Human Rights and Equality Office, or the Court Service, to maybe more intensive training sessions, certificates, and different types of accredited courses, and everything in between. But there was still 44% of people that said that they hadn't attended anything of this nature. And this is when I felt I was specifically in the breakdown of different professionals that you'll see who responded, specifically targeting groups that the Act was very relevant to and operated in their professional practice. And even beyond the kind of numbered or statistical breakdown of this, it was also in the qualitative answers to the survey where challenges highlighted by different practitioners or medical practitioners would have said, a general practitioner, for example, said, not knowing enough about it, definitely need more education. And consultant talked about doctors not really knowing how the systems works, the legalistic language, and needing more practical examples of how the system could work. And finally, a social care worker who was saying that they felt that they understood the Act, but that the differing viewpoints or traditional and outdated practices being applied continued, and other people's lack of knowledge of the Act was a huge challenge, a lack of knowledge of the Act and its broader implications. The final theme that I want to touch on this morning is around issues around supporting decision making in a really practical sense. And this was brought up by both the professionals and, again, case study participants, but particularly by professionals when they were talking about how they felt the Act had introduced complex processes, increased the levels of bureaucracy that they had to work with, and increased their workloads in different ways. And this was from registering or creating formal decision-making arrangements with people or supporting them to do that, right through to just figuring it all out and how it applied to their professional practice, especially, I suppose, in the early days of the Act's implementation. So an independent advocate talked about, we do not place applications directly. However, we do work with individuals going through the process. It is too complicated for a lot of clients to fully grasp, and the different strands are not clearly illustrated. The DSS, for that I think it's the Decision Support Service, is very geared towards older people and very muddy. Guidance there relating to younger citizens such as care leavers with ID or complex needs and safeguarding vulnerabilities. And at this point, I suppose it's important to highlight that none of the participants in the case study dimension of this research had ever accessed any training on the Act. And they did say that this could very well be because they were very busy, and there may have been ad hoc webinars organised by a school or a service or something here and there, but they felt that they were still few and far between, and with all of the admin that they had to go through in terms of accessing services and stuff, they could have missed it, but they weren't very common, at least in their opinion. And they would have, given their own experiences and interest in it, signed up for one of them. The other main issue that came across here was kind of a varied knowledge and awareness of how to support people in practice. And this was particularly evident when we were thinking about people who were non-speaking, sometimes speaking, or who communicated differently. So this would have come up generally in response to the survey, but also in particular questions when we were asking people about how you would support people in your professional practice or the barriers that you faced. And some people gave really detailed accounts of all of the various steps that they could do within their professional practice or setting and how they could go about that. And others went, well, I'd have to figure it out when I got there, or I really don't know. And, everything sort of in between for that. So while some of the different professionals would have spoken about, I don't know, I'd have to go ask for help. I'd have to find that out on the day when somebody was there in front of me. Others were saying, well, I could bring in an interpreter or a translator, which seemed to conflate being non-speaking in this instance with being deaf and using ISL interpreters. And of course, people do use ISL interpreters, but the cohort that I was thinking about in this instance wouldn't necessarily benefit from having an ISL interpreter present, or wouldn't always benefit from that. And and thinking about those kind of things and not really knowing how to change their practice. A lot of them were open and were thinking that this should be more embedded in professional training and practice at different stages. They were like, why isn't this part of our healthcare education and training in our courses? Why isn't something that's been more broadly in part of how we're taught about the Act and taught about it in different ways? Beyond their actual knowledge and awareness of how to do this, there was also other practical barriers to supporting somebody in practice, including limited time and access to resources. So whether that was a translator, an interpreter, or somebody with the knowledge and skill set to help you through these kind of processes, and just time. Just having the time, and this was particularly evident in responses from people working in healthcare who talked about the healthcare system, as you'll see there from the quote on the slide from a doctor saying, the healthcare system is under huge strain, which results in time and resource constraints. Often people need a lot of time to facilitate often time-consuming communication methods, and staff can lack this. Also, a shortage of appropriate and experienced multidisciplinary team staff to help medical staff in navigating these situations. So they don't have the time. They may not have the training or the awareness to do this by themselves, and I think that would also help. They shouldn't always be going to other people. It's important that those other staff and team members are there, but there could be basic skills that could be built up for this cohort as well. And they don't have the resources in different other ways within their own settings. Finally, a speech and language, the occupational therapist said speech and language therapy can be vital in enabling communication, and there's shortages and subsequent waiting lists from the services can be a huge barrier. So there was different types, I suppose, of resources in this. Access to communication passports or plans were also a different thing, where people were saying this would have come up particularly with the emergency services, but actually across the board going, well, I go to the documentation to figure out how this has been done before, how people have interacted with somebody, how we can do this. And then the documentation doesn't exist or it's not readily available, which leaves me without the kind of support to figure this type of stuff out. But also documentation in more accessible formats and needing to build up more of those kind of resources so that they're readily available or easily accessible when they're needed at a time when somebody is making this type of decision or they're going through this kind of interaction with a healthcare professional or with somebody else. So those were some of the main themes that came across in the research, and it's a flavour of the different things. I think they could have analysed them in a number of different ways, and there's so much more that I want to do and want to explore with it. But the main conclusions that I was able to draw from the work that I have done so far was that unfortunately there seems to be a continued focus on substituted decision-making options or options such as the decision-making representative order under the Assisted Decision-Making Act, particularly for people who are non-speaking, sometimes speaking, or communicated differently. And as I said, across the world, people with high support needs or people who were non-speaking were originally the ones that supported decision-making options was being explored for, and it was very much for them, but it's not coming across maybe in the implementation of something like the Act in practice. Also, that there might be an increased focus on things like capacity assessments, but without the similar focus or similar resources and awareness on things like how we actually support decision making in practice and the elements of the Act, like the guiding principles that do this and that bring it on. And finally, one of the main things that struck me is the lack of supports, particularly for young people and their families, whether that's in seeing themselves as decision makers for the young people and understanding the Act and being involved in deciding what support we want, in helping their families to navigate the different options that are available and figure out what might suit them, and how to support, how to build different forms of preferences and communications into decisions, and how we document this and show this when we need to in a formal way. And that if we want this to be a success and to do it in a way that maximises and promotes people's human rights, we really need to support people better to help them to do that and to figure it all out. So I will leave it there, and I look forward to your questions later. Thank you.
Thanks very much, Tina. That's a fascinating overview of a very in-depth research project, and I'm sure everyone will have gotten a lot out of that information and have lots of questions for you. So For all of our attendees with us today, you can post your questions into the Q&A box on the bottom of the screen. So you can type your question in there and you have the option to ask your question anonymously. If anyone needs to have access to the mic or the camera to ask their question, for example, through the interpreters, then you can just press the raise hand button and we'll enable that for you. But first, before we get into the Q&A, I want to turn to our remaining two panelists. We're going to start with Nem Kearns from Neuropride. So over to you now, Nem, to give your reflections and responses to Cliona's findings in this research.
Thank you, Eleanor. I first just wanted to just thank you for the invitation to be here and really welcome this research. It's such an important topic. It's so well laid out and highlights the areas that we can improve and the areas where there is danger of enacting the law in letter but not in spirit and not actually advancing people's rights. The introduction of the AGM does present an opportunity to reframe how we think about disabled people and centre them as rights holders and active decision makers in their lives. But in order to do that, in order not to squander that opportunity, we really need to build a scaffold around. We understand that and the resources available to people, whether that is the individuals themselves, their families, or the professionals who are tasked with enacting and implementing the AGM. I want to stress the people currently falling under its jurisdiction, but also people who may fall under its jurisdiction in the future. I was very struck by how much Cliona highlighted that people are not kind of given the opportunity or the information to kind of future plan or to be involved and have those discussions that are often coming up against a block or a crisis or an external inciting factor. We're kind of rushed to establish something, to set something up, and I think that's partially what's pushing towards this substituted decision making being overrepresented, when really we should be going for supported decision making, and definitely for the person who is the decision maker and whose decisions are being made about, having an active role in deciding what's best for them wherever possible and being supported to do so. Sorry, I should say Neuropride Ireland are a cross neurodivergency disabled persons organisation, kind of representing adults more so. We do interact with and advocate on behalf of people under 18, but our full membership is, for safeguarding reasons, is restricted to those over 18. So when we're interacting with people younger than that, it would be in the presence of a parent or legal guardian. So I will be speaking more to adult experiences, but it's also kind of want to say that it's extremely important that we do not forget those under 18 or do not wait until their 18th birthday to kind of suddenly expect them to figure all of this out. Sorry, I do apologise. I have no electricity, so I'm looking at scraps of paper, and I realise how reliant I've become on technology. Yeah, so I think that areas that are really kind of urgent and concerning in our point of view, we would represent when we speak of neurodivergency. We are, of course, including autistic people, ADHD, dyslexia, dyscalculia, but anyone with any neurological or neurodevelopmental difference to the extent that it impacts on their day-to-day lives. So that would include people with acquired brain injury or TBI. That would include people fetal alcohol syndrome, just anyone with neurological difference. So a lot of the people that we represent would indeed be people who are non-speaking, partial or sometimes speaking, or who communicate differently. And one thing that is very, I myself would do partially, I do experience situational mutism, which is very difficult for people to believe because the rest of the time I don't shut up. but it's there's quite a lack of understanding in general of that experience, particularly for people who are much more minimally speaking, or one that it can be quite a dynamic experience, again, as Cliona was highlighting with the people that she was speaking with and interviewing, often it is a range and a combination of communication methods which can all be happening at one time. And it can be changed from day to day whether someone would prefer to communicate through an augmentative alternative communication through an app on their phone or through word or through gestures or and also again kind of I thought it really came through with Cliona speaking of how much the people who know that person well, what a role they often play in supporting that communication or developing individualized methods of communication and also in understanding when different communication methods are more appropriate for that individual. Another thing that is often very, very underestimated by people is just how if you if you're not someone who communicates fluently verbally in particular or through something like ISL, of how tiring, how absolutely exhausting, and how much resources it can take to communicate, which can often lead to a bombarding of questions or a bombarding of information, an overwhelm, which often has a feedback loop of making it more and more difficult to communicate in any method. So time is, and I think that's something that obviously there will be circumstances where emergency circumstances, but I think that the time element is something that is not fully enunciated under the Assisted Decision Making Act, which I would like to see kind of more brought into the people using it and people utilizing it, and both those working with a loved one, a family member, but also with professionals of um, trying to identify how the process can be slowed down, how there can be time for the individual to communicate, to express themselves, to absorb information, be given information in a way that's acceptable to them, and to process that information. For example, in the being taken in to 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 speak with three clinicians, to communicate with three clinicians, and not being given information about what to expect in advance, not being given um, examples of what they would be communicating about in advance, and also not being given the other environmental information so that they don't have to spend as much of their resources on processing the traveling to the navigating in the building to the meeting the people. All of that is actually resource taking, and those are resources that will not be available for stress of communication. Um, and sorry, I have lost my place. And I think that we also need to really forefront that kind of foundational right to accessing your rights is to know your rights, is to know what your rights are, and to kind of meaningfully have an understanding of the options available to you and how you can exercise those rights in whatever method or capacity that is. Um, I think that that's something that is not currently, there's not enough in place for families, for professionals, for individuals to be able to kind of uh, have an awareness of what an understanding of what's available under the ADM, what their options are, how they can individualize them to the best uh, as available under the law, and how to communicate with an individual about what their will and preferences on how to express their will and preferences and decisions in the future. There's also many young neurodivergent people are not given an opportunity or encouraged to be included in decisions that affect them and to make decisions that impact them. As a young person, most of us will experience a scaffolding as we grow up where our parents or caregivers kind of allow us to stretch our wings in a safe way, kind of scaffold us, and to exercise our autonomy, to exercise their decision making. And it is kind of like a muscle that you develop and you learn and you grow. And if people are prevented from engaging in that, we cannot get any sort of accurate baseline of what sorry, I'm just very loath to use the kind of the idea or concept of decision making capacity as a kind of a thing that is measurable and exists and is static. But that kind of that learned helplessness, institutionalization is also massively impactful on someone's exercise of their decision making rights. We need to kind of take into context also a person's experiences and circumstances and seek more to support and empower than put in place a decision making agreement that kind of doesn't focus mostly that kind of part of really supporting people in every practicable way, every way possible. I feel is getting very overlooked and rushed past in a lot of contexts with the AGM. There's also insufficient reasons for people who do want to support a person in their lives to make their decision or to be included in as much as possible in their decisions. There's not resources readily available. It's also very difficult for families to know where to go to get this information they need on these different systems. There's also for non-speaking people and partially speaking people, augmentative and alternative communication is not as readily available as it needs to be, but also there's a lack of information and a lack of resources. There's also a lack of understanding of what that is, and that it covers every alternative form of communication, whether that's technological or not technological at all, and also that it is individualized. How a person best communicates is something that they need to explore, and they need to be supported to explore, and also the role that loved ones and networks that of support around that person play, that they need also to be supported and have resources to learn and explore those options. Sorry, I think I am going over time.
That's okay, Nem. If you could just wrap up in the next minute.
I will indeed. So I kind of another thing I just wanted to highlight is how often communication methods are removed from people, particularly if they are partially speaking at any other time. It's given more verbal communication, still given more weight. We do hear of people, particularly in inpatient mental health settings, where their communication devices are taken from them, and that may be a phone with no kind of workaround, kind of like privacy, but no alternative is given, or they communicate a decision in a hospital, in a healthcare setting, but they don't do it verbally, and they're told they need to give consent or withhold consent verbally, that other forms will not be counted. And sorry, so I just kind of want to really highlight that we say that we accept all forms of communication, but we still very much see verbal communication as the most valid form, and that's something we really need to interrogate. And also just to mention that I understand that it can be really difficult to, especially if you really care for someone and want what's best for them, to accept that everyone has the right to make bad decisions. And that just because we've all done things that we regret or that we get a bit older and go, that wasn't the best thing I could have done, but it was our decision to make. And also kind of, sorry, the very last thing I want to kind of just a little example. I'll try not to spend too much time on it. So this isn't an ADM example, but I think it's just something to think on. So we were supporting a family who had a young person who wouldn't stay in their chair in school. Would get up from the chair, move, might leave the room. They'd get injured on one occasion, so there was a lot of discussions on how to get this child to stay in the chair, how to get this young person to stay in this chair. There was all sorts of communication with different clinicians, with the family, with round and about. They were like they'd gotten to the point of getting parental consent to strap the young person into the chair. Eventually, time was taken to communicate with the young person, and the issue was that the chair was painful. The chair was uncomfortable. A lot of them also have physical impairment. A very common occurring one is hypermobility, which is instability of joints. Is one. and also the announcements constantly going off over the intercom. So they didn't need to strap the child into the chair. They didn't need to do any of this or override consent or get special letters. What they did was replace the chair with a comfortable beanbag chair and make sure the announcements were done at predictable times so that they could put earphones on to avoid the sensory overwhelm. So I just want to say, when it comes to the ATM, when it comes to any decision making, also we need to really remember to be curious about why someone is making or is not making a decision, and do our best to communicate to see their reasons, the individual person, where they're coming from, if they do understand and if they just don't like the options presented to them. So I'll leave on that note.
Thanks very much, Them. Really valuable insights there, and great to hear the perspective from an organisation led by people with this experience. So now I'll move on to Anya Flynn, who's the director of the Decision Support Service and was part of also on the advisory panel for this research, to give your reflections, Anya, on this research and its findings.
Thanks so much, Eleanor. Thanks, Cleena. Thank you for inviting the Decision Support Service to participate in this really valuable piece of research, and for the invitation to provide some miscellaneous thoughts of my own by way of response today. I certainly welcome the opportunity. Perhaps an opportunity very briefly to introduce the Decision Support Service. Many of you will know what we do. We're established under the Assisted Decision Making Capacity Act, and with a range of functions which derive from the Act. Primarily, and I think this is called out in Clena's research, to provide information and guidance, to promote awareness and confidence, to register and then practically supervise the performance of new decision support arrangements. And that includes a safeguarding function around managing complaints where they come in if those arrangements aren't going well. We have been operational since commencement of the Act in April of 2023, and we're now a service with 100 people working with us. As part of that broader function to promote awareness, to be a source of information and guidance, we have a really busy information services team answering 600 to 700 phone calls per week. But also as part of that, and this has been touched on when people were giving their thoughts this morning, we do a fair bit of outreach, engaging with diverse groups of professionals, but also really importantly, and as far as possible, with regular people, the potential users of our service, their carers, their families, those people who are going to be impacted by the legislation or are experiencing its impacts already. Because as the research very eloquently establishes, we can only know how well an act, a really important reforming piece of legislation like this, is working by hearing from those affected, by establishing how its implementation is being rolled out in real life. There'd be an opportunity, a requirement, in fact, for our parent department to do so in a studied way 5 years post commencement, to look how it is delivering in practice, and to do a systemic and systematic review. I think there are certain things, and they've been touched on today, that we do need to look towards. How has the experience been for people who are coming out of wardship? That continues. The Decision Support Service isn't involved. That's the business of the courts. What has been the call on the inherent jurisdiction of the court, mentioned briefly this morning? To what extent is that filling a wardship-shaped gap? Hard to say. And then we in the DSS also have an opportunity to carry out certain thematic reports of our own. So yes, we've issued a standing invitation since 2021 for anyone here today, or if you're aware of others who are interested in hearing directly from the Decision Support Service, do please get in contact. We'll be running a public information campaign. We have one ongoing, and there'll be a further one happening through 2026, focusing particularly on the theme of advanced planning. Just if I may think about the Act itself, I think this is an Act which got an awful lot better when it was in development, and we're going back now almost a decade to when it was reaching the final stages before it was finally signed into law. And I think, and I always say this, that with the really essential input of various NGOs and importantly disabled persons organisations, it became a better piece of legislation in its final stages. Nobody claims it's perfect, and I think the ongoing review will be very important in that regard. But if we think about it, this was an act which was going to be called the Mental Capacity Act, as it's called in other jurisdictions. The Decision Support Service was going to become the Office of Public Guardian, with all of those vestiges of paternalism and protectionism, and then the name change was effected. So I think it's to the credit of people who really argued for the inclusion of UNCRPD type principles that we see an act which calls out giving effect to will and preferences as far as practicable. And those really important sections mentioned by Taighde in her research and today around the need to support communication, that the fact that somebody has a communication difficulty or requirement doesn't mean for a second that they lack capacity, and communication must be understood, respected, facilitated, supported. Again, and it's been mentioned several times today, and I applaud it, the guiding principle around supporting people as far as possible to exercise their decision making. That's called out in a particular code. We call it Code 1, the overarching code that the DSS published on supporting decision making and assessing capacity. But that priority on supporting decision making, we often point to the brackets around the word capacity in the Act. It's not a rush to assess capacity or to think of new ways of accessing consent. It's about supporting people as far as possible before you rush to do the formal thing. As Taighde mentioned, and Nem has just touched on it, sometimes time is the scarcest commodity in trying to do that. But we must be conscious of that need for a personalised approach. And I think there's lots to reflect on in Taighde's research about that need to meet people where you find them, if you like, and to access the tools which they prefer in order to facilitate them in that engagement in the decision making that matters to them. Sometimes, and I've said this before, the Act is doing its best work and can be most positive in its effects when you don't formalise. So that the new framework is really important, so much more progressive, I think, than what it replaces. But sometimes knowing when you don't need to go to the framework can be very important. Thinking about those guiding principles is a really important way of navigating how we support people in their decision making without thinking, is somebody on the bottom tier, the middle tier, the top tier? And that's literally language which I have heard. So again, whilst this is all very well intended, I think we need to reflect meaningfully on some of Taighde's findings about how, well, I would conduct a capacity assessment, or I would get a professional to conduct a capacity assessment, and then I would think about which tier matches the need. That may be where you need to end up. It absolutely shouldn't be your starting point. If I would reflect on some of the statistics that we have seen, and we have now on our books in the DSS, close to 7,000 registered arrangements. By far the biggest number of those are enduring powers of attorney. We will probably register our 5,000th enduring power of attorney quite soon. Those aren't activated enduring powers of attorney, incidentally. Only 200, some of them have moved to where the attorney has needed to step in and begin to make decisions. Planning ahead is really important. Planning ahead is not just for older people, and I hope that that is called out in our public information campaign, which is forthcoming. There has been much less call on the lower tiers of support. Our stats, incidentally, are published every month on our website. So we see, fewer than 200 decision-making assistants, just 162 co-decision makers. I think that would be concerning if people were defaulting up the tiers instead. And we need to be vigilant about that, and whether the court is putting in place decision-making representative orders, or people are applying to the court without fully investigating the lower tiers of support. But again, the lower tiers of support are voluntary arrangements which people should not have unless they need them. Coming out of the courts, I think we do see, and I'll conclude with some observations about what we've seen in case law, if I may, which I do find encouraging. I think there has to be a concern to ensure that court-based process, where it is engaged as a last resort, is involving the person, is inclusive of the person, is giving proper effect to one of the sections of the Act which says don't do this without having the person involved and having access to advocacy. Thinking about how we see the Act playing out in other sectors, I would say this is an Act which is only going to work, but it is embraced across the whole range of sectors impacted by it. The DSS isn't on the front line. We are more than happy to input into training, but we don't have a direct responsibility for training. We are more than happy to support any kind of initiatives around it. But it is very important that those working in health and social care, where I think really good work is happening, incidentally, are embracing the Act and running with it in their own worlds. If we think about the banking sector, for example, with whom we have quite a bit of engagement and where perhaps there has been a certain tendency to want to formalise or to think we must send everybody to the decision support service, please don't. It shouldn't be the first step. I think we do need to see an embracing of the language and the principles of the Act in those frontline engagements. And this is new. This is a lot for various sectors to come to terms with and to understand the language and, importantly, the ethos of the Act. And I include, of course I do, in that the decision support service. We must look to our own materials and resources, thinking about young people who are, of course, the focus of Taighde's research. If anybody listening thinks that they want to hear more from the DSS about that, absolutely, please do engage. We keep our resources, our materials under review. Our digital first approach is not digital only, and we have an accessibility policy to meet the needs of those who can't engage with us digitally. All of this overseen by our stakeholder forum, comprised of persons who have expertise by experience. We meet with them quarterly, and they are frank in their exchanges with us about what we need to do, what we need to do better. So we ourselves in the DSS must be committed to continuous improvement. And in conclusion, then, if I may, I see a lot that I find really, really encouraging. I do like to, end on a positive note always when I speak about this. I think we need to keep our eyes on the prize here. This is about moving away from that era of paternalism to very much a rights-based focus. Nobody's claiming that the Act achieves that perfectly, either in its language or currently in its implementation, but I think that the outlook is positive. Perhaps just to conclude on a couple of matters coming out of the courts, which we keep a good eye on. I'm thinking about two judgments made at the circuit court level where I think good precedent is emerging. So that in both of these cases, somewhat confusingly, are called AB because these are anonymised, but happy to direct people towards them. So that we had Dublin Circuit Court reflecting that communication difficulties must not be equated with a reduced capacity to make decisions. That focus of communication in Taighde's research is specifically identified as something, again, which has to be facilitated. And picking up in a recent case on a similar theme, Judge Shannon, in a case focusing on a person's right to marry, a man with a disability who wanted to marry his long-term partner, Judge Shannon called out the importance, a theme very much emphasised today, of supporting people in their decision-making, not the rush to assess capacity or to think about whether somebody needs one of the tiers of support, but again, supporting people as far as possible, facilitating their communication and helping them to make a decision which matters to them. So Judge Shannon said that the statutory framework is clear. Capacity must be assessed, I'm paraphrasing, in a way that is supportive and with fidelity to the individual's will and preferences. And he ended with this zinger, which I quite like. The law must protect, but it must also empower. And that's what we need to keep a very good eye on. So I commend this research again. Delighted to be here today and looking forward to hearing more. Thank you.
Thank you very much, Anya. Great to hear those practical insights as well in terms of the ongoing implementation of the Act and also the need for continued public awareness and education on the provisions of the Act as well. So I think at this point we're going to take a very brief comfort break, if that's okay, especially for our interpreters, but for all of us too. So if we just take about 3 minutes of a break and then we'll come back to answer the questions that you have for us. We have received some already into the Q&A box, but you can continue to add more there and I'll direct those then to Taighde or whichever member of the panel might best be able to respond. So let's just take a 3-minute break and we'll be back then to answer questions. Hey, welcome back, everyone. So we have a question in the chat about whether a parent can be appointed under the Act to exercise their adult children's right to vote. So, Clean, I'm going to come to you first with that.
Thanks, Eleanor. Yeah, so the Act focuses on decisions relating to personal welfare and property and financial affairs or property and affairs. So, my understanding of it is that a decision making representative could not be appointed, it wouldn't come within those for somebody to vote on somebody else's behalf, and that there probably wouldn't be the appetite out there to change that either for the one person, one vote and how that would work. I do know that broadly speaking, they're trying to make processes more accessible, and the Electoral Commission and others are working hard to figure out the barriers that are there for people and how they can make processes more accessible for them, including ballot papers, understanding the process and all of that.
That's great, thanks. So I don't see any other questions in the question box at the moment, but if anyone wants to ask another question, you can still type in there, or you can raise your hand and I'll enable the mic so that you can ask your question aloud if that's more accessible for you.
Just while we're waiting for another question, one of the other points that might have come up in the research was around the general principle under the Act that somebody should be in a position to make an unwise decision, and NIM would have raised it in their response. And I realised that it wasn't one that actually made the cut into the presentation for today's webinar, because there was so many different options that could have been included in the final report and in this. But the challenge that people were facing, I suppose, one of the positives that I saw was people's recognition that this was previously happening and that the Act was changing this and saying, no, we need to support people through this, and we need to support people in making unwise decisions, or in recognising that that is not alone enough to challenge somebody's capacity. But in doing so, then I suppose a lot of professionals in particular and different people going, but it's very complicated, and it's something that we really, really struggle with in trying to figure out how we're doing this, if we're doing it appropriately, if we're adequately managing our own liabilities, policies, other concerns in other areas, or the kind of things that are being listed to us on one hand with our obligations and our duties under the Act, and how we do this in a way that is appropriate. The other side of it then was if you are relying on a family member, a friend, or another chosen supporter to facilitate somebody's communication and interpret their communication for you, how can you be sure that they're adequately reflecting or accurately reflecting somebody? And, you know, they may be making an unwise decision, but could somebody who's interpreting for them be going, no, it's fine, this is what we're doing instead? And making sure that everybody is very much on the same page for that would have come across very much in the research as a challenge people were facing, but I felt a challenge that they were trying to embrace and balance the risks in many, many areas. Not everywhere. There were some people who were very worried about the risks and still thinking that that required a capacity assessment, but it was a positive inclusion or a positive point that arose in some of the things.
Eleanor, if I might just come in there, the business about the unwise decision does come up a fair bit in engagement that we have with various stakeholders as well. And as you know, just to be clear, the Act doesn't say everybody now has an unlimited right to do unwise things. None of us does, I guess, have the right to do unwise things where perhaps they're going to impact on other people. But rather, as you say, Cliona, what the Act says is that wanting to do or having decided to do the unwise thing isn't conclusive of a lack of capacity to decide to do it. And I think a thing which comes up a lot is, but we mustn't hold people who have a disability, disabled people, to that higher standard. You know, we make unwise decisions all the time. I may have made one or two already today, but I'm probably not going to expect to be challenged on those. Whereas there's potential for somebody with a disability to have their unwise, in quotes, decisions challenged more readily than another. And then there is that point, as you mentioned, where sometimes people working in service provision think that it's somehow hostile to the whole concept of safeguarding, as if they have to remove the protections which, for very good reason, might have been in place before, because they can't, to their mind, established consent to those, and perhaps now people have a right to do unwise things, but it's probably not part of somebody's broader will and preference to put themselves in harm's way or at risk. So it is that kind of balancing exercise. But I do see good work being done around that. But you've touched on some of the sensitivities which it necessarily highlights about liability and exposure, and trying to balance empowerment with keeping people safe. And being safe is probably part of all of our own grand plan.
Yeah, that was definitely something that came up, and as I said, it didn't necessarily make the cut into the presentation, unfortunately, but that was just in the interest of time.
Oh yeah, there's lots to talk about. Yeah, absolutely.
Another one that didn't quite make the cut that I might touch on very, very briefly, if we don't have any other questions coming in, and then we can maybe wrap up, is around people's professionals in particular feeling the need that they would have to verify somebody's communication or the style of communication that they had in before they could proceed with the decision. And one of the most noteworthy examples of this was a question that I created in the survey that specifically asked people, you encounter somebody who is non-speaking, sometimes speaking, or communicates differently, and they're registered decision-making assistant. You don't necessarily know them well, or you maybe haven't met them before, but how can you proceed? And in that instances, the majority of people said, well, I'd need to verify their communication with a third party. And in some other aspects of supporting a person in practice, the qualitative answers to that question would have indicated, well, you'd need like a doctor and another person. You'd need two other people to verify how this person was communicating before you could ever engage with them, and how you could do that. And that was particularly concerning for me, because I was thinking of the people who took part in the case study portion of this research. But by and large, a lot of the people that I know who maybe communicate differently might only have a small subgroup of people who really and truly understand their communication really well. And if you are always asking or always reaching for somebody, a third party, to verify that, then you may be limiting their involvement in their decision making. You're not respecting an agreement that they've made under the Act. And that person, that totally independent third party, might not exist. And again, if we're thinking that might be pushing people towards, or they might feel that therefore they need a court order in order then to be able to take part in that, or to have that engagement doing. It was only a small sample of it. It would need further research in order to have this properly, but the reaching for a perfect verification, and the felt that they need to do that for more than one person in some instances, raised a bit of concern in that area. And I think it's something that we need to understand more, and maybe challenge, to make sure that everybody's getting a fair chance to be involved in decisions about their lives.
Okay, let's highlight something. Sorry, I'm jumping in. That does actually call out something that we encounter as well, Cliona, where in fact, it was the banking sector said, okay, so somebody has, and this is where they have formal arrangements in place. So presumably one likes to think everything else has been attempted, and now they have in this case, co-decision maker. And the feedback from the bank to us was, well, then we will go off and kind of, check out that co-decision maker is doing this properly, and that they are actually, and so we've done that, thank you. We actually have quite a statutory role around that. So they've been through the hoops, they've ended up with a registered arrangement. So that's the thing about having one of the formal supports, if and when you need them, that all has actually gone through quite the process in order to be put in place. So the idea that you need to go through this kind of independent verification exercise to make all of that okay, when probably I'm guessing the same stakeholders wouldn't have if somebody had been a ward of court, or if they had an enduring power of attorney in place under the old Act. It's the challenge of the new, I guess, but there is a rigour around this. And I think perhaps that people should take confidence from that, while at the same time, the point where we all come in saying, you don't necessarily need the new framework. It's there as a problem-solving tool so that decision-making can be facilitated and achieved. But please start with the entry-level guiding principles about supporting people in their autonomous decision-making first.
Yeah, we've just had a question into the chat about banks again, Anya, which, as you know, are a constant challenge, I think, in implementing this vision of the Act. So again, where banks were kind of refusing to accept lower tiers of support and demanding a DM or a decision-making representative order be put in place, and what workarounds can people use to push back, I think, when they're met with that resistance, to ensure that the person doesn't want or need a DMR, and yet the banks are requesting it, is how I'm interpreting that question there. Yeah.
Yeah, my work will never be done. But so in an individual cases, people actually do contact us, and we have literally contacted Main Street banks to say, what are you doing? But again, not ideal. My point about how this act does need to kind of percolate down to the front line, and it's new. Nobody's acting in bad faith here. I have every confidence, but it's just ensuring that there isn't that default to the very formal that people might have an instinct for. There's a code of practice for financial services professionals. There are codes, incidentally, for all of the decision supporters. We have done work with the central bank. We've done work with the Banking and Payments Federation. I think if somebody has that individual experience, they're welcome to contact us. We'll do what we can. But it is a question of really that embedded knowledge being established. So yeah, I would also commend that in those individual circumstances, it might be appropriate to contact what they still call the vulnerable customer units in the bank to say, I've met somebody on your front line who doesn't really seem to be running with the act in the right direction, and they may be able to arrive at a solution for you.
Great. So I don't see any remaining questions. So all that remains is for me to thank Cliona for her incredible research and our amazing panelists for their fantastic reflections and applications of that work into different contexts, and our great interpreters as well for making this webinar accessible for everyone, and all of the audience members for participating and asking really important questions that has given Cliona and the others an opportunity to share how the Act really should be applied in practice to achieve the human rights-based vision that we all want it to achieve. So thank you all very much. We've been recording the session, so we will hope to be able to share that with people in due course. And of course, the findings of the research will be widely shared, and I'm sure will be used by all of you and promoted by all of you here today with those who need this information in order to take this work forward. So thank you all very much.
Thank you all.